We appreciate you coming out today on a very cold and windy day in Washington, D.C. For those of you who aren't familiar with our organization, the National Whistleblower Center is a nonprofit public interest organization specializing in the support of employee whistleblowers. It was established in 1988 in order to provide whistleblowers with legal representation and support that they could not obtain elsewhere. The center alerts the public to the existence of legal protections and to provide training materials and workshops on how to assist nuclear and environmental whistleblowers. Our focus today is whistleblowing in the nuclear industry, and we are fortunate to have with us today 4 distinguished individuals who have had firsthand experience with whistleblowing in the nuclear industry. We also have 2 major announcements today. The first is to announce a significant development in a case involving a whistleblower in Arizona who had litigation against the Arizona Public Service Company. And the second major announcement is to announce the expansion of new programs with the National Whistleblower Center. Specifically, our new programs will be as follows. We are announcing today the formation of 2 new offices of the National Whistleblower Center. They will be regional offices located in Arizona and Florida, respectively. And 3 of our panelists today will be involved in the operation of those regional offices. Thomas Saporito, who is seated at the far end of the table, will be involved in the operation of the center's office in Florida. And Linda and Alan Mitchell, who are seated immediately to my left, will be involved in the operation of the center office in Arizona. We also are announcing today that we will be soon distributing a training video which is entitled Blowing the Whistle, How to Protect Yourself and Win. It is narrated by Daniel Ellsberg, who himself is a noted whistleblower from Pentagon Papers fame. And the video features Linda Mitchell, Vera English, and Thomas Saporito. We do not have a complete version of the video available today, but for those of you who are interested in, we will have a brief preview of it later. Our format today will be to hear brief statements from 4 individuals, 3 of whom are featured in our new training video. We will then open the floor to questions and answers, and following the question and answer period, we will have a preview of the training video, which we estimate to be about 15 minutes in length. I would like to introduce Michael D. Cohn, who is General Counsel of the National Whistleblower Center, and he will make our first introduction.
Hello, I'm Michael Cohn, and before we begin, I would like Pastor George to do an invocation. You can't ask a Baptist minister to stand up and not speak a little bit, so I'll speak just a little bit. Having an opportunity to work with David and Stephen and praying for Linda and Alan and Thomas and Sarah, I found out one thing for sure, and that's impressed me deeply, is that truth needs to be prime, and truth absolutely is necessary. In 1 John chapter 1, verse 7, it says, "If we walk in the light, as he himself is in the light, we have fellowship one with another. And the blood of Jesus, his Son, cleanses us from all our sin." Reminds me of a little song that I learned as a child. This little light of mine, I'm going to let it shine. This little light of mine, I'm going to let it shine. And the whistleblowers are letting that light shine, letting it shine over the oppressed and the harassed and to the whole world to let them know that the nuclear industry can be safe and a wholesome environment. Let's pray, shall we? I thank you, God, for being who you are and for intervening on behalf of man. Sometimes we doubt, and oftentimes we fear, but we need you to keep us from being overcome with pain and sorrow. But Lord, you're always there. You're there in mercy and might. You're there with power and with truth. And you're there for now and forevermore, lighting our path. Your truth is light. And in Jesus' name, we will let that light so shine. Amen.
So that Pastor George flew all the way in from Arizona and is a testament to the spirit of whistleblowing and the oftentimes deeply religious conviction the whistleblower holds and provides strength. In fact, that is a great form of strength to the next whistleblower I would like to introduce, Vera English. Vera worked for GE, General Electric, between 1972 and 1984. In July of 1984, she was terminated. 24 days after her termination, she filed a complaint with the Department of Labor. She blew the whistle on unsafe work conditions and defects in the production of nuclear materials. Vera was completely successful in her litigation at the beginning. The Department of Labor investigated, and then a formal hearing was held. An administrative law judge issued a decision, a copy of which is in your press packets, and entitled Vera English versus General Electric. In that case, the judge ordered and found that GE had harassed and illegally terminated Vera English and had done so in such a horrendous way that the judge ordered $70,000 in compensatory $1,000, in fact, maybe the largest compensatory award under the federal whistleblower protection laws in for the NRC to review the record carefully and determine that General Electric violated the Atomic Energy Act and issued a fine of $20,000 in civil penalties, which GE had to pay. All that said and done, GE's lawyers said, wait a second, Vera English filed her complaint 24 days after she was fired or terminated, but you know what? Her case should be thrown out because she didn't file it soon enough. Pretty hard feat to find a lawyer within 24 days and file in time and figure out what law to sue under. But under the law, it's not the date you're terminated or things of that nature. It's the time which you learn you're going to be terminated or learn that discrimination is going to take place. And under the law, there was a 30-day statute of limitations. And when you counted it all up, it was a little more than 30 days. And Vera English case was thrown out of Department of Labor after she had been successfully vindicated before an administrative law judge and had been awarded compensatory damages. Vera did not stop there. She regained her strength and went into federal district court to pursue a state cause of action to protect whistleblowers from harassment and intimidation under state law. She went, and her case was dismissed. The judge said, you know, it's not right for whistleblowers to bring causes in state cause of action because this Department of Labor remedy was sufficient, and Congress only meant for whistleblowers to sue in Department of Labor, and they can't bring a state court. It was cause of action. It was preempted, and the Court of Appeals upheld that decision, and it was left to the Supreme Court of the United States. And the Supreme Court ruled 9-0 in favor of Vera English in a landmark decision which held that whistleblowers have the right, nuclear whistleblowers and environmental whistleblowers have the right to go into state court and obtain relief for the type of harm their employers were reaping upon them. In fact, the General Electric's lawyer, Peter Nash, the quote is found in the press packet in a June 1990 USA Today article, said, "The High Court ruling is going to have a negative impact on companies trying to run their business as they see fit." And that is correct. Just as Vera English, or let me say, just as Rosa Parks created a negative impact on how people were going to be transported in the South and what was acceptable conduct, Vera English blazed the path which made it difficult for employers to discriminate against whistleblowers without having to face court action. Vera, then after winning before the Supreme Court, her case went back to the initial judge who threw out her case, and that judge again found another technicality and tossed it out. And today, after 10 years, losing her house, losing her job, being blacklisted from the industries since that time, Vera has placed a lot of trust in the Nuclear Regulatory Commission, and the Nuclear Regulatory Commission has not come through. The bottom line is that it is now up to the Nuclear Regulatory Commission. In fact, the National Whistleblower Center is announcing that we are pursuing, before the Nuclear Regulatory Commission, that GE is a nuclear licensee, which means to operate their plant they must have a license from the Nuclear Regulatory Commission, and we are requesting an amendment to that license requiring that they protect whistleblowers at GE facilities such as Vera English, and that she be reinstated and compensated before that plant should be allowed to continue operation. With this introduction, it is with great honor that I have the privilege to introduce Vera English.
Thank you, Mike. Hello, I'm Vera English, and before I say a little bit, I'd like for you to look at first-hand whistleblowers that are the eyes and ears for the Nuclear Regulatory Commission. We are very real people, and we are people that are not crazy. We are people that are skilled in our professions and know what we're looking at. In these utility reactors and manufacturers, there are no windows. You can't peek in and see what's happening. Only we, the employee, the eyes and ears for the NRC. I am a former worker of General Electric. Their nuclear division, fuel plant in Wilmington, North Carolina. And I started to work there in 1972 through 1984, whereby that after bringing to their attention safety violations within a nuclear controlled lab and deviations from procedures, I lost my job. I lost my career. In August of 1984, I started lawsuits against General Electric. And for the next 7.5 years to 8 years, I spent my life in court And the result of these years is just that I receive no pay, no back damages for all my efforts. I believe in all good conscience sake that I did what was right. I did it not for only myself, my co-workers, but I did it for you and our future generation. And if I had to do it over again, I'd still do it. What did it do to me? I lost my home, my personal savings, my job, of course, my self-esteem, and trust for people and for a jurisdictional system. Not only that, they tried to destroy my integrity, my credibility, and my character publicly. And in so doing, it hindered future employment. I truly hope that my legal battle with General Electric has set a precedent that will be able to help others in the future. But my greatest betrayer was the Nuclear Regulatory Commission itself. NRC. NRC is a symbol to me. No one really cared. I say thank you.
Thank you, Vera. Next, I'd like to introduce Linda Mitchell. Linda is a former Arizona Public Service engineer at the Palo Verde Nuclear Facility located near Phoenix, Arizona. Palo Verde is the largest nuclear generating facility in the United States. With the help of the National Whistleblower Center, Linda helped forge legal case law that holds that a hostile work environment is a type of discrimination and that nuclear employees do not have to suffer this form of discrimination. Simply say, and Linda will, I'm sure, tell you that the campaign of harassment was very significant that was laid against her after raising serious safety concerns at the Palo Verde plant. And it's my pleasure to introduce Linda.
Thank you, Michael. Good afternoon. My name is Linda Mitchell, and I'm from Buckeye, Arizona. And for more than 20 years, I worked as an electrical engineer, designing, constructing, and operating nuclear power plants. My most recent employment from 1985 to January 1993 was at Palo Verde. I reported safety concerns so serious that the Nuclear Regulatory Commission was forced to fine Arizona Public Service Company, APS, the operator of Palo Verde, more than $300,000 in civil penalties. In the process of bringing forth these safety allegations, I suffered extreme retaliation from APS, and I got virtually no assistance or help or relief from the NRC. Between 1985 and 1989, I reported safety concerns to Region 5, and they were left unaddressed. In 1989, I brought those safety allegations to the Nuclear Regulatory Commission in Washington, D.C. And after I brought those safety concerns to the attention of the Washington NRC officials, I was threatened with criminal prosecution by the Region 5 NRC officials. In September 1989, Blaine Ballard, who was the Arizona to the Nuclear Regulatory Commission, I immediately reported this to the NRC and they failed to even investigate this allegation. In 89 and 90, the harassment got so bad and the retaliation increased that I was even ordered to destroy a report that I'd co-authored about my safety concerns by my management. I sent a copy of that report to the NRC and asked them to investigate it, but Region 5 neglected to investigate, so the APS harassment campaign against me continued and increased. In 1990, a coworker pointed to a charred, burned dummy mannequin and said that this is what's going to happen to Linda Mitchell if she doesn't get her act together. After the NRC failed to take any actions on any of my concerns, I took matters into my own hands and filed a case with the U.S. Department of Labor. And in July 1992, I had a major breakthrough when an administrative law judge ruled in my favor and ruled that APS harassed me because I raised significant safety violations. The judge found that Palo Verde's attitudes towards addressing safety problems was so abysmal that it created a cancer which allowed it to grow could lead to a catastrophic disaster to the public. After waiting 3 years, the NRC finally took enforcement action, and they penalized Arizona Public Service Company a $130,000 civil penalty for creating a hostile work environment against whistleblowers. When APS finally paid the fine related to my case, the company denied any wrongdoing, criticized me, said I was a hypersensitive complainer, and asked the NRC to return their check. The NRC cashed the check. All I ever wanted to do was do a good job and to be conscientious of the public safety and the safety of nuclear power. And I felt like my life's been destroyed because I raised the safety concerns at Palo Verde. And I think the people at Palo Verde are still afraid to raise safety concerns. So I think it's time the NRC and discriminated against. Thank you.
Next, I'd like to introduce Alan Mitchell. Alan is Linda's husband. He's a former electrical engineer with the Arizona Corporation Commission, which is different than Arizona Public Service. The Corporation Commission deals with rates of the utility, but the ratepayers have to pay. Simply said, his association with Linda Mitchell cost him his job, and at this stage in their life, they are happy to announce that they now have the resources to open a regional office of the National Whistleblower Center. With that introduction, it's my pleasure to introduce Alan Mitchell.
Thank you, Michael. Good afternoon. My name is Alan Mitchell, husband of Linda Mitchell. I'm a degree electrical engineer with more than 22 years of experience in the field of nuclear power plants, in the field of design, construction, startup, and operation. I was previously employed with the Arizona Corporation Commission with duties of monitoring the Palo Verde Nuclear Generating Station. In 1989, I prepared and presented testimony before the Arizona Corporation Commission and showed imprudent management out at the Palo Verde Nuclear Generating Station. As a result of my testimony, Arizona Public Service was ordered to refund approximately $3 million back to the ratepayers, whom I call the raped payers. APS attempted to discredit me in retaliation for my testimony at the Arizona Corporation Commission, my oversight of the Palo Verde plants for the Corporation Commission, and my marriage to Linda Mitchell for raising safety concerns at the Palo Verde Generating Station. After I lost my job at the Commission, I supported my wife in her attempt to bring up safety concerns through the agony and the harassment that she had experienced, even as far as taking her to work and returning her. I do not know how Linda survived much of this experience, but the trials that she and I both went through were tremendous. And because of these difficult experiences, we now desire to help others that are blowing the whistle. We ask that National Whistleblower Center take and let us be a part of their organization, and they've agreed to take and let us be the Western Regional representatives. We appreciate that. Thank you.
This afternoon we're announcing there was a long litigation that was ongoing between Mr. Thomas Saporito and Arizona Public Service Company regarding his claims of discrimination following his attempts to be rehired at the Palo Verde Nuclear Generating Station. We're announcing today that he has settled and resolved that litigation. To give you a brief background on that litigation, Mr. Saporito had filed the complaint himself and represented himself before the U.S. Department of Labor. He went through a trial before an administrative law judge representing himself, and in May of 1993, an administrative law judge from the Department of Labor ruled in his favor. Following that decision, the Arizona Public Service Company revealed that one of the witnesses for the company may have lied under oath during that proceeding, and now we are announcing today that the case has settled. The revelation of the lying under oath prompted the NRC to launch a very intensive investigation, which we believe is ongoing. It has launched what we believe to be one of the most significant probes in the history of the NRC into wrongdoing committed by a nuclear utility company. Mr. Saporito has other litigation pending against two other nuclear utility companies, Florida Power and Light Company, where he worked as an instrument and control technician in the late 1980s. That litigation for wrongful discharge is still pending before the U.S. Secretary of Labor. And he has another case of blacklisting against Houston Lighting and Power and a contract company, Nuclear Support Services, which followed his employment at APS. He was fired after reporting safety concerns in Houston, and he has litigation pending over that termination. We're also announcing today that we have filed with the Nuclear Regulatory Commission a petition pursuant to 2.206 of the Code of Federal Regulations, requesting the NRC to investigate the practices of the Atlantic Group Incorporated, which is a contractor of APS and other nuclear utility companies. Mr. Saporito worked for the Atlantic Group when he was employed at Palo Verde. We're requesting the NRC to investigate TAG's involvement in the misconduct during the Saporito litigation, and also to investigate the continuing blacklisting by TAG of Mr. Saporito, where he is unable to get employment in the nuclear field. So it is my pleasure to be able to introduce to you Mr. Thomas Saporito.
Good afternoon. My name is Thomas Saporito. I currently reside in Jupiter, Florida, and I have approximately 20 years of experience in the instrumentation and control field, 10 of which is nuclear related. I became employed at Palo Verde as a contract technician working for a contract company called the Atlantic Group, a contractor differs from a utility employee in that we're only there for a refueling outage, and then we leave. So it's usually 3 months, 90-day outage, and then we leave and go to another plant. When I was at Palo Verde, it's a 3-reactor site. I worked at Unit 2, was told that we would be working a subsequent outage at Unit 1 after we finished at Unit 2. During my employment there, I raised numerous safety concerns to management, and I did not get hired to work at Unit 1. My coworkers did, and I filed a complaint, and Mr. Colapinto has told you the result of that litigation. My concern is that my fellow co-workers with the Atlantic Group and the in-house utility workers at Palo Verde witnessed my termination, and they know it was focused on my raising safety concerns. The NRC, the Nuclear Regulatory Commission, did absolutely nothing to protect me, did nothing to protect my job, did nothing to support the illegal conduct of discriminating against me. I feel that my coworkers, be it the contractors and the in-house utility workers, were scared to come forward with any additional concerns they may have seen out at the plant because they saw me lose my job. And that's, the NRC calls that a chilling effect. And I think it's widespread and pervasive, not only at Palo Verde but at other nuclear facilities, because in my opinion the NRC has never properly defended a nuclear whistleblower. They have regulations under 50.7 of the Code of Federal Regulations which require them to investigate these type of complaints, and they don't do these investigations. On the other hand, the Department of Labor is not much better. My initial complaint against Florida Power and Light is still in front of the Secretary of Labor. And so you put both of these government agencies together, and there's not much incentive for an employee to raise concerns at a nuclear plant because they know they're going to lose their job, and if they dare go to court, it may be 5 to 10 years before they get their case resolved. So I sincerely hope that the NRC Commissioner, Ivan Selin, and the administrator for the United States Department of Labor can come to terms and resolve some of these inadequacies in both agencies so that employees will be encouraged to raise safety concerns, and that the general interest of the public will be protected from an accident. Thank you.
Okay, I guess we're ready to start our question and answer period. Go ahead.
Can you tell us what the settlement consists of?
Okay. The settlement consists of the following. What we were able to say is that Mr. Saporito has agreed not to apply for employment at APS or with any company related to Palo Verde, and it does provide for compensation, which the parties to the agreement have agreed to keep confidential, and we are going to abide by those terms.
When was the settlement actually reached?
The settlement was recently reached and recently formalized within the last couple of weeks. It was actually signed, I believe, near the end of December and formalized within the last week. Yes.
Can you explain the reason why you agreed to something like this? It sounds like if he can't work for APS and he's still being shut out by some of these other plants because you haven't settled the tag complaint, he still doesn't have a job. Is the compensation so huge that it makes up for that?
Well, let's say this. Mr. Saporito raised what we consider to be very significant concerns at APS. He also litigated this case on his own as a pro se litigant without an attorney for almost 2 years. He is a person who has gone the extra mile in litigating his case, living out of his car, living with relatives, and what you've not heard today is the extreme, hardship that these cases impose upon individuals such as Mr. Saporito. And that's the only comment I wish to make.
Yeah, but we really haven't heard anything about you've settled. Can you give us some details about something? I mean, what's going to happen as a result of this?
Well, what is going to happen is that the allegations with respect to the safety, the allegations with respect to the lying under oath in the Department of Labor proceeding have been turned over to the Nuclear Regulatory Commission. It is their job to fully investigate that. We are calling upon them to fully investigate it and to continue their investigation and get to the bottom of it. We've been supporting these cases for a long time, and we do not often see a utility company come forward and say, we did in fact have a witness who lied under oath. We think that's very serious, and we want to get to the bottom of it. That's something that Mr. Saporito could not do during the course of his litigation. That's something that has to be done by the proper governmental authorities, and it is up to the NRC to ensure that the integrity is being maintained by these officials who run a nuclear power plant.
Can I just follow up?
Sure.
The NRC complaint is against TAG, not APS. Is that correct?
The NRC is investigating both APS and TAG.
They are?
Yes, they are.
So APS is not off the hook with the settlement?
The settlement does not cover anything with respect to the Nuclear Regulatory Commission. It resolves litigation between the parties, between Mr. Saporito and APS. The NRC has its own proceedings ongoing, and we want to make sure that the NRC does its job in order to make sure that these plants are run safely. Yes?
I was going to ask, I mean, we've sat here and we've listened to these whistleblowers talk about how NRC has fallen short of the mark in protecting them. What makes you think that this time the agency will in fact carry through and do what in its investigation of Mr. Saporito?
We're not confident that the NRC will do that. That's one of the reasons we have called a press conference today, is to bring attention to the nature of these allegations, the significance of them, and to hope that the public, through their awareness, will be able to know what is going on in terms of these types of allegations. The NRC has a terrible track record in terms of responding to these types of charges and investigating allegations and making sure that there is something done to enforce the nuclear safety regulations in this country.
At the same time, Palo Verde has had a pretty bad track record itself in terms of whistleblower allegations that have been brought both to the Department of Labor and to the Commission. I believe it was after your case, Mrs. Mitchell, where NRC sent a special team out there to look at allegations of perhaps sort of a surprise kind of interview of employees on your right of why do you think they came up with walked away with such a different view than what you've seen at the station?
First of all, it wasn't a surprise. In my opinion, the questions were focused to a certain amount of people, and they were asked in a manner as to intimidate people that did say that they had a concern. I spoke with many people. I made many notes in a journal. The impressions that were given to me by the people that were interviewed, many of them who said that they were afraid to raise concerns, were intimidated into shutting up by the NRC, the officials themselves, to the extent of the utility tracked the people who met with the NRC through the compliance department. Evaluation at all. The people that were afraid to come forward, that they did recognize there was a pocket of people that were concerned, were afraid, were actually the engineers, like myself, the other system engineers who had technical knowledge of the plant. Many of the people that they interviewed, to give a large number, to show that there was a large number that was not afraid, were not people that were technically capable of even raising a concern.
I have a question about the lawsuit that Mr. Saporito had against APS.
Right.
What was the basis of the lawsuit? Wrongful termination, failure to rehire him? It was a civil case, I assume.
It was a civil case filed before the U.S. Department of Labor under Section 210 of the Energy Reorganization Act. The basis of the complaint was the failure to be rehired. Most of his co-workers who worked with him during an outage where he was working at the plant were rehired. He was not. He was the only person who was eligible for rehire who was not rehired for that particular outage. That occurred in...
The outage happened in January of 92.
In January of 1992. It was later revealed, the reason we believe that the allegations with respect to lying under oath are significant is that the person who was responsible for making the selection initially denied that he knew Mr. Saporito was a whistleblower, denied that he knew that Mr. Saporito had raised safety concerns at APS. It's subsequently turned out that he in fact did know, the APS supervisor did know, and that was the reason for not hiring him.
But this is an addition. A Department of Labor judge had said that the reason that he was not rehired was because an employee at APS had said that he didn't want to rehire him because of his whistleblowing activities. The lawsuit settlement that you're talking about today is an addition to that, isn't it?
It's that lawsuit.
Okay.
It covers that lawsuit.
So this lawsuit, I guess I don't understand, what court was it filed in?
It was filed with the U.S. Department of Labor. It's a civil administrative remedy under Section 210 of the Energy Reorganization Act. Yes.
I wonder if maybe in lay terms you could explain to us what, in Ms. Mitchell's case and Mr. Saporito's case, what the safety violations were, what the potential consequences of the safety violations could have been.
Okay. I'll have Tom and then Linda explain that in layperson's terms.
My position was instrument control technician, and we call it I&C in nuclear abbreviations. I&C, Department of a Nuclear Plant, is the actual heartbeat of the plant. When a reactor is taken offline for refueling, the instrument control department has a lot of safety-related equipment that must go back and be recalibrated, and some of it needs to be replaced. And if that doesn't happen in a timely fashion, then the outage gets delayed. All these utilities now do their outages, and they try to set a benchmark of 70 days or less. If they accomplish that benchmark, the executive managers of these nuclear plants are monetarily compensated. And that's their incentive to achieve these expeditious refuelings. The problem lies, and in my own opinion, the reason nuclear whistleblowers are discriminated against is because the outages get interrupted. It's $1 million a day to keep your reactor offline because they have to replace that power somehow. They have to light up oil-fired power plants or gas-fueled power plants. They're all more expensive than nuclear. So it's very expensive to keep a nuclear reactor offline. Now, when I got there and raised concerns, some of these concerns were unbelievably significant. Like, you know, I had a couple of my coworkers were down at they have what they call RCP pumps. They're reactor coolant pumps. You have to pump water through the reactor all the time or overheat and melt down. It's that simple. Well, these pumps, they have to be repaired and maintained. The seals have to be replaced. Our instrumentation actually measures how fast the pump is spinning. And then we have these sensors that if the shaft would crack, they the shaft expands if there's a minute crack, and that's important to detect that so the reactor can shut that pump down. Otherwise, the pump would explode. The pump is in the radioactive loop, or the primary loop of the reactor. So if the pump explodes, the pipes rupture, you have a loss of cooling action. You lose all the cooling water. There's nothing the man has made which will prevent that reactor from melting down. It's going to melt down. So it's very, very safety-related equipment. Well, my co-workers at that plant, I was in the control room and I was monitoring this calibration. They adjusted this probe to set it a specific hundreds of thousands of inches away from this shaft. And as they move it in and out, I can see the voltage on my meter in the control room going up and down. We were communicating by telephone. They were at the reactor. I'm in the control room. And then all of a sudden, they start hammering on the sensor because the sensor is bolted to a support plate of the reactor coolant pump. And as you tighten the bolts, it changes this distance. So it's a very elaborate procedure. There's certain steps you have to perform in a very sequential manner. And if you disrupt that manner, the calibration is bogus. It has to be redone. It's illegal. It violates the technical specifications of the plant. You have to follow the procedure step by step. So they were hammering on this thing because every time they go to tighten these bolts, it would change the calibration. So I reported that. It was one of my concerns, and there were numerous others. But what happened is it delays the outage, you see. Now that job has to get redone. And if they can silence the nuclear workers by intimidating and harassing them and create a situation that the workforce is silenced, then, these people aren't going to raise concerns such as that. And so this reactor coolant pump is going to go back online, and it may or may not detect whether that shaft is cracked or not. So that pump has a chance of exploding, and you have a chance of a loss of coolant accident, which otherwise would not have happened. And just for your information, there are an excellent article by the Houston Chronicle displays all these whistleblowers, and these are all significant safety concerns that the Nuclear Regulatory Commission would not otherwise know about, because they only have a handful of inspectors, 1 or 2 at each of these plants. They cannot possibly, it's not humanly possible to be everywhere in this plant if you're only 1 or 2 people. So, sorry.
I raised many safety concerns from procedural violations to improper documentation that didn't reflect what was in the field or in the units to operate the plant safely. But I think the most significant ones in relation to what the NRC penalized Arizona Public Service for was I was a system engineer for the emergency lighting system, which had to operate when you had a plant emergency to shut the plant down. And I was reporting for 4 years that those systems did not operate and were not properly maintained. And we had an event in March 1989 that proved that the system would not operate and they could not see to shut the plant down. At that point, it was a very scary time, in our opinion, when the plant couldn't be shut down in the time that it was required to by the Appendix R requirements.
Are there any further questions?
Do you see a need for a change in federal law as far as investigating these matters, or is the law already in place, it just needs to be enforced? Or?
There are laws and regulations in place. There's a federal law which sets up the Department of Labor remedy. That is Section 210 of the Energy Reorganization Act. The NRC also has its own independent authority to investigate these types of complaints under its regulations. That's 10 CFR Part 50.7, which prohibits the discrimination or harassment and intimidation of employees who raise safety concerns and makes it a condition of license. In other words, the NRC can take independent enforcement action against one of these plants if they are found to have committed a violation. In our view, the current system is not adequate to respond to these complaints. The system takes too long. It can take upwards to 5 to 10 years to resolve a complaint through the Department of Labor process. The NRC in the past has implemented a policy of delay and deferring to the deferring to the Department of Labor before it would even investigate a complaint of harassment and intimidation. It is only because of the significance of complaints like Linda Mitchell's and complaints like Mr. Saporito's, which have caused the NRC to begin to move independently now and investigate earlier in the process. You may be aware that the NRC has been in the process of doing a self-study to examine how it handles whistleblower complaints. That was a result of the Senate hearings that were held this past July following a NRC Inspector General criticism of the way NRC handles whistleblower complaints. The Mitchells, Mr. Saporito, Ms. English, and other whistleblowers around the country, in addition to the National Whistleblower Center, have provided input to the NRC, and we are awaiting that report to see what the NRC has to say about it. There need to be a lot of changes made.
But it would appear then there are signs, hopeful signs, then that perhaps change may be in the works of the NRC. You're awaiting this report, and you've gotten some response apparently from up on Capitol Hill. You mentioned there was a hearing held. Do you view these as optimistic?
We do view these as optimistic signs, but we're very cautiously optimistic, and we're going to wait until we see what the final report says, and also the old saying that action speaks louder than words. And we've heard a lot of lip service before from the NRC that they're going to protect whistleblowers, and we're not confident that that is going to happen until we actually see tangible results.
When do you expect that report?
It's due out this month.
And in response to an earlier question concerning why do we think the NRC might be more responsive, basically there should be more pressure on the NRC due to the Senate Oversight Committee of Senator Joseph Lieberman. And this is a test. If they will come through and adequately investigate and look into harassment and intimidation of whistleblowers at Palo Verde and the numerous other nuclear facilities around the country. It's not an isolated situation. There are dozens and dozens of these cases of harassment and intimidation, and it is time that the NRC is going to have to step up to the plate, hopefully before the Senate committee, and say, this is what we are going to do to protect whistleblowers. And the decision hasn't come in, whether they're throwing a ball or a strike.
Are there any further questions?
I just one
Sure.
other one. I haven't talked to any of the people of the contractor or the utility company or anything, but I can just hear the argument, well, that these are former employees, disgruntled people, and they're just after us. How do you respond to that?
Well, there's a pattern to these complaints. There are certain utility companies around the country that have more complaints against them than anybody else. And thanks to the revelations that were made as a result of the Senate hearings this July, we now are able to see some statistics on where the complaints are coming from. And to give you an example, to use Palo Verde as an example, there were more harassment and intimidation complaints received by the NRC from workers at Palo Verde than all of the other plants in Region 5 combined. And I believe it was one of the highest sources of complaints in the entire industry.
And also to address the general assertion that whistleblowers are disgruntled employees, if you take the example of, say, whistleblowers at Georgia Power Company, there you had the assistant general manager, the number 2 person at the plant, who had received his performance appraisals, had been given a raise, and was rated very highly, makes the allegation that upper management, including executive vice presidents, are conspiring to submit false information to the NRC. That is not a disgruntled employee, and the other situation was another a general manager, an assistant to a senior vice president at Georgia Power Company, wrote a confidential memorandum saying that the utility was illegally transferring control of its license. His annual appraisal was exemplary and contained in it information saying that there's no known limit to how far this whistleblower can go. Excuse me, no known limit how far this manager can go. So I think there's clearly, you know, if you take any specific whistleblower case, you will see that there's substantial evidence to demonstrate that these are not disgruntled employees. And in almost every case, these people have given up their jobs and their livelihood and face severe hardship. So it's you know, I'd say it's a case of disgruntled utilities upset with employees and are doing determination. An employee is a lone person dependent on paychecks and is not in a position to beat up multi-billion-dollar corporations.
I would like to say something for just a moment. I'd like to throw a question back at all of you. What would happen to our nation today if there were no whistleblowers? What do you think could happen in the nuclear industry or with a reactor that should be dismantled instead of being started up again, knowing how corrosive that uranium can be, that today they find cracks in steel cores of these reactors? You think about it when you go to bed at night. And if you squelch the voice of the whistleblower, you have nothing to help you, for the industry doesn't care. The bottom line is money. They could care less about you and I. Think about it.
If there are no more questions, we will get started with our video presentation for those who want to stick around and view the preview of the video, the training video. Thank you.